Okay. Yes, Mr. Fear.
I'll just go over the short adjournment. I've just been doing a stock take of the grounds of appeal to see what else I need to address from the documentation. I'm looking at the way they're set out. Ground 1, I believe I've dealt with.
Yeah.
Holistic
Yes.
exercise, etc. Ground 3, the evidence of what mother would have heard or would have done, I think I've dealt with, in terms of the inferences she drew from her appreciation of the evidence. Ground 4, the finding that father cared for FJ in the bedroom on the night of the 3rd, I think I've dealt with. I haven't dealt with ground 5 or ground 6, which is itself a very broad ground.
Yes. Well, yes.
The ground 2, I don't think I've addressed.
Well, everybody talks about ground 2 and ground 1 together, don't they?
They have, yes. I don't think I've addressed it discreetly. But insofar as it's said that the judge didn't consider evidence which pointed towards the possible finding that father was the perpetrator, he in fact does so in the judgment. My lords, I think it's at paragraphs at the beginning of opportunity, from paragraphs 80 to 83, he speaks of father being unwell and so on, but this is outside the window for rib fractures. There is paragraph 85 about the father finding things difficult on the 2nd of November. There is the father caring for the child on the 18th and 19th, and text showing he was awake and the baby was crying during the early hours. There is paragraph 91, the father looking after the child alone for 40 to 45 minutes while the mother's out with neighbours texting the mother. There is then paragraph 101. She specifically deals with the counter-evidence pleaded by the mother through Miss Grief, the matters that they put to the judge as evidence of the father's inability to cope and suffering from strain. Paragraphs 127B, C, 129, 130, and 131 are all about criticisms made of the father in terms of telephone calls made and things not said to the police. And I think that is all I would ask your lordships to look at. But it's not right to say that the judge didn't have or pay any regard to those. She does, and specifically deals, in fact, in one of those paragraphs with the criticisms made of him by those acting for the mother.
Thank you.
Well, ground 5
Yes.
is having concluded the most likely time for the rib fractures on 25th, 26th of November. The judge erred in making a finding that it was unlikely in that period the father would become so stressed as to lose control. I go back, my lord, to the simple point that she had these two people in cross-examination.
That's important.
It's
within the trial judge's discretion.
It is.
Yes.
And
that's what you say about that.
really the same is so of the catch-all in 6.
And 6.
In terms of whether she stood back and looked at this, I can see why, in the way the judgment is constructed, it may be possible to think that there is a linear approach to this. What in fact the judge does is say there are these discrete issues which I deal with, 2 matters of the father's character which will inevitably impact my consideration of the rest of the evidence in relation to him. There is the question of opportunity and of crying, which the judge feels she must address to help her in consideration of the rest of the evidence. But I've hopes shown your lordships that when she then looks at that evidence, she does in fact step back, takes it step by step, tells you where she's drawn her inferences from, and reaches conclusions which on the Volpe and Fage standard are perfectly satisfactory. So that insofar as there is any not standing back, it is not sufficient to reach the standard which should allow this appeal to be granted. And I do make the point in our skeleton that when I was looking at the broad canvas, that's normally in a different context, and that's not the context here.
Thank you.
And unless there are other questions that I can deal with, that's really all I had to say.
Thank you very much. Ms. Worsley. Thank you, Mr. Field.
Thank you, Lordship. Much time has been spent on the detailed consideration of the judge's factual considerations and her determinations, and that is, of course, a key issue. Whether the judge took a wrong turn or took a wrong starting point, I think everybody's accepted it's not an easy case. But as Mr. Fiennes just referred to, the Volpe point, the judge had both these parents giving oral evidence, they were cross-examined, she was best placed to assess their credibility, to assess the atmosphere in the courtroom. There was criticism in relation to paragraphs 4 and 5 of Volpe that she failed to give balanced consideration. And those are some of the criticisms that have been raised in oral arguments today. I think the primary one is that she failed to give, or she failed in fact to conduct the balancing exercise properly. It's one of the points that's been raised. On those points, I adopt the local authority submissions in their entirety, and I don't intend to reiterate any of those points that have already been made by Mr. Fiennes on behalf of the local authority. But of course, I do submit that this was an adequate judgment, and I've set that out in our skeleton argument. The decisions, the factual decisions, were those that the trial judge was best placed to make. I've spent some time in our submissions setting out the factual issues of the case because, of course, I was representing the trial. There are no transcripts. We've done our best, and certainly I have the benefit of Mr. Latham's detailed notes. I want to start with the presumption that Ms. Grief submits that the judge started in the wrong place with the leg fracture, because, of course, what the leg fracture demonstrates is it was something that was obvious at the time that it had been caused. Dr. Cholwa's evidence is it would have been specific in its presentation, and your lordships have already been taken to Dr. Cholwa's evidence.
I'm not sure, maybe I'm just misunderstood exactly how you characterise Ms. Grief's submissions. There was an exchange between herself and me. I'm not sure she says that the judge was wrong to start with the leg fracture. I think, as I understand it, she's wrong. Says the judge was wrong to start with the question of whether the mother would have woken up if the leg fracture had been caused on the 3rd of December. I don't think, as it were, she says the judge started with the 3rd of December or the leg fracture, that was wrong per se, to look at that as the first point.
Well, I agree that it should be the first point because it's pivotal.
Yes.
Because once the leg was fractured, it was an obvious injury.
Yes, and I think she also goes on to say, as I understand it, even if you start there, the one thing you shouldn't do is stop there.
No.
You know, you've got to there. You've got to look a lot further. But I don't think she actually said the judge was wrong to start there. So I don't think there's anything.
Well, I accept. I'm sorry. Maybe that I took.
Well, I think it's. I think she said the judge was wrong to start with a particular aspect of the related to the leg fracture, which is this question of whether the mother would have woken up, etc.
But the considerations in relation to that should be explored, I think, in further detail.
Right.
You've been directed to the video of the 3rd of December, and much has been made of that. The point is this. The baby was asleep. It's a 20-second video, and the injuries could well have been caused before that. The baby demonstrated signs of distress and then fell asleep. So the significance of the video is, as the judge sets out in her judgment, doesn't assist her either way.
Just show us, remind us where she says that, would you? I know we've looked at it, but I can't immediately put my... Oh, it's in the end. It's 126.
126, page 21. And so the judge can't be criticised for that because, in essence, it doesn't assist one way or the other.
But the child had been put in this seat in winter clothes.
What we know is that as far as the parents' evidence is concerned, and your lordships asked us to check our notes over the mention adjournment, there is in fact no evidence of how the child was on the father's return on the 3rd of December when he returned
No
to
evidence.
work. The father's evidence was that the baby was unsettled during that night, and he gave evidence as to that.
Third, fourth.
Third,
Third, fourth.
Friday, Saturday,
Yes.
3rd to 4th.
There's no evidence of who the child was when the father returned.
No.
And until when? Until the night time.
Yes.
Period.
He said the baby was unsettled overnight, but there is no evidence as to how the child was being put in the pram, out of the pram, or anything more. So it's silent in relation to that.
Right.
So far as the mother's evidence is concerned, as to the location of the father that night, she didn't know if he was downstairs or upstairs.
Right. And
So again,
neither of them knew where they were. Is that right?
he couldn't recall.
No. So
Sorry, you've moved on. Is this right? There's no evidence from either parent as to how the child was during the afternoon of the 3rd of December. I thought there was something, but
The father's evidence, when he was asked, was how, because of course the parents were together after the visit to Boots. And so thereafter they were back at home together. The father's evidence, when he was caring for the baby, was that the baby was unsettled overnight.
yeah. No, I park overnight just for a second. I'm just focusing just for a moment on the time of the video, which I think you've actually said that you say the baby's shown to be asleep in the video.
Yes.
Which I think is something that I didn't pick up from the judgment.
You said signs of distress and then asleep, and I was going to come back to that point to ask where that came from. Actually, sorry.
No, you. I think you was sorry. I think I understood you to say that in the video the baby was asleep.
Yes, the baby was asleep.
And which I don't think we get from the video. I could be wrong, but I don't think I got that from the judgment.
Ah, okay. I don't think it's in dispute, but the baby was asleep
Right,
during
and
that
then
video.
I understood you to postulate rather than say it was in the judgment that it's possible that the baby could have been distressed and fallen asleep.
I do. Wrong? That has to be the conclusion from the way in which the judge has approached that evidence.
Right, but
because she doesn't say that it's determinative of the fracture not being already inflicted at that point.
So you're saying that an explanation of, or a way of reconciling the video with the judgment as it has come out, is that the child had been injured before the father came home, had been presumably distressed by the fact his leg was broken, but had fallen asleep, and that's the condition in which it was perceived in the video.
Yes.
But you're offering that as an explanation, not saying that there was any evidence to that effect. You're offering that as the explanation for why the judge didn't get any help from the video at 1268.
Well, your lordship's correct. It doesn't say, in fact, in either reference in the judgment that the baby was asleep. But I don't think there's any dispute by any of the parties that the baby was asleep in the videos.
The difficulty that I got, it's not the sleeping. I wrote down, and I think I've misrecorded it, that you said the video was 20 seconds. It showed the baby in signs of distress and then asleep. Now, the simple question that would help me is during that 20-second video, we don't have any reference to it in the judgment. Is it that there was no evidence at all as to whether the baby was distressed or not, and for the whole period that's on the 20-second video, the baby was asleep?
Yes, I'm very sorry if I was inarticulate in relation to that. The baby was asleep.
The whole time in the video.
That lasted
okay.
20 seconds.
So I can put a line through the video showed signs of distress then, yeah?
No.
Yeah.
The point I made was the judge was entitled to find that the baby had been injured
earlier,
and
might
the
have been
distress
distressed
had abated.
and would be asleep in the
and
pram.
then was asleep.
Let's just explore that. Bear in mind, Alan Hopping, we don't speculate, all right? But there's a sort of the dog that didn't bark point here, isn't there? Isn't if the child had been injured, as the judge found at some point earlier in the day on the 3rd, there is no evidence at all that the child was distressed or showing any symptoms consistent with injury before the night time.
No, that's right. There's no evidence about that, but that isn't to say, because of course what we know about this baby and what's clear is this was a baby that was unsettled most of the time. This wasn't a child that was a bubbly, smiley little baby. Sadly, this is a baby that was unsettled for most of the period of time that he lived with his parents.
But we know, don't we, that the child would like to have shown distress when moved after the fracture occurred.
We do.
There's no evidence that that happened before of anything consistent with that on the 3rd before the nighttime 3rd fall.
No, and similarly, there is no evidence of that throughout the course of the weekend. Because, of course, all the parents say on the 4th and 5th is that the baby was unsettled. So again, there is no evidence of either parent saying that the baby was distressed when the nappy was being changed, which is, of course, the evidence that Dr. Trawler gave. And that's set out paragraph 66. Because she was clear to say, at the end of that paragraph, a non-perpetrator of the fracture may not realise, my lords, I'm sorry, that's at S13.
Yeah, non-perpetrator may not realise what the cause of the distress is. Non-specific.
But it's in relation to decreased movement
Yes.
that raised concern when that's seen by the non-perpetrator, for example, when changing a nappy. So
Yeah.
the point that I say that the judge was entitled to find was that there was no evidence of anything of concern happening over the course of that weekend. The mother didn't give evidence of anything of concern when she woke up in the morning on the 4th of December, which on the mother's case the baby must have been injured at that point. But she doesn't mention that. And so one of the parents is clearly lying about the presentation of the baby or have failed to notice. And your lordships have been taken to the finding that the judge made in relation to the father failing to appreciate that the injury had been caused.
Sorry, both parents gave evidence, it was common ground, that the baby was unsettled on the 4th and 5th.
Yes.
Unsettled.
Unsettled. But that's a word that's been used throughout this case.
I see.
There was nothing specific.
Very unsettled, in fact.
Yes. But there was nothing specific about the child's presentation on the Saturday or the Sunday prior to the swelling being noted at about 5 o'clock on the Sunday that either parent could pinpoint would have given rise to the fracture. And that's the difficulty. And the judge, therefore, I submit, was entitled to find that this mother, knowing all that she knew about this mother, and she sets that out in the judgment, that she's an attentive mother, she's attuned to her baby's needs, would have been more likely to have known that there was something wrong with the baby's leg. Because she specifically criticises the father for that, and that is the finding that she makes in relation to him.
Which is the paragraph you specifically want to rely on for the proposition? I remember it, but I just can't remember it now.
145.
About the mother's attentiveness. Your point being that if this judge had seen this mother give evidence and therefore informed her view that she was attentive and hence would have spotted. I mean, sorry, is this your point? The judge was entitled to take the view that, having seen the mother, that the mother was attentive and would be likely to have noticed over the 4th and 5th if the father had broke the baby's leg on the evening of the 3rd. I mean, that's what you're submitting, I think.
It is.
Yeah.
She sets it out at 120 through to 123 in relation to how she approaches the issues. Firstly, she's dealing with the issues in relation to where their father had cared for the baby, and then whether the mother had heard the cry.
Oddly enough, that just appears to be going back to the question of would she have known at the time that the fracture was caused, rather than drawing a conclusion based on the fact this mother must have known on the Saturday or the Sunday, and the fact she doesn't mention it is because she's lying and covering it up. The judge doesn't seem to say the latter bit, does she?
She may not explicitly say it, but it's clear from the findings that that is what she says, my lord. It's clear that she doesn't believe the mother's account.
But she does not accept that this mother would have slept through B's reaction to having his leg fractured during that night. Just doesn't seem to deal with it afterwards, the rest of Saturday and the Sunday up until the swelling.
My lord, 123, paragraph 123, she talks about there are inferences I draw from the medical evidence, from the evidence about how the family had lived and cared for B, and the evidence about the mother as a parent. That's what I'm referring to. The same would apply if the father had fractured B's leg during the daytime that weekend. The mother would, I am satisfied, on the balance of probabilities, have been aware and would tell me. The fact that there is no evidence of B being in such pain, and that's the pain of the fracture, and it's clear we've clarified that. Like Dr. Chowa described, from the point when the father came home on the 3rd of December, causes me to find in the balance of probabilities that he was not injured after the father came home. So on that basis, she rejects the mother's account.
So I read 1, 2, 3 as being focused on whether the mother would have been aware of if the father had fractured B's leg during the daytime that weekend. Isn't she just dealing with that specific possibility? I understand. I think your wider point is that the judge does make a finding at 120 in the middle about the mother being attuned to B's needs and moods. So there is some material for you to say. If you know the only explanation or the one explanation for the mother not raising the distress that the baby would have been in over the weekend because it had a broken leg was because she was covering up.
Yes.
Right. Okay.
And that's what I say the judge sets out.
I'm not sure I see it quite as explicitly in the way that you're submitting to me. I can't. I think middle of 1, 2, 3 is a slightly more specific point about whether the mother would have noticed the father if the father had fractured the leg during the daytime, i.e. when they were together. That's because that's what she says. I don't think I can't tell at the moment that she's making the broader point that you're making.
I accept she doesn't explicitly say that, but by the finding, she clearly has rejected the mother's account.
Okay.
And can I assist any further in relation to that point?
Difficult, isn't it? Difficult cases.
It is a difficult
Worrying
case.
case too.
And it's for that reason I say that she was best placed, because of course she
Yeah.
heard the evidence and she was able to assess both the parents and the witness box.
Yeah. Well, that's. I'm not surprised that you and Mr. Fian come back to that point because it's a very important point.
Mr. Fian's already made submissions about the findings the judge made in relation to the house and the prevailing conditions.
Yeah.
And in relation to ground 3.
Are we going to move away from the 3rd of December now, or not? Because if you were going to move away from it, I'd want to hear what you have to say about the inconsistency, which, or potential inconsistency, was pointed out between paragraph 120 and 71.
Yes, in relation to Dr. Charwa.
Yeah.
Yes, you're going to
Yes,
come
that's
back.
what I was coming to, in fact, my lord. That's in relation to ground 3.
Yes.
I wanted to address you in relation.
That's fine. That's fine. I did.
Great.
In your own in your own time. I did. I just thought you might have been planning to move away without dealing with it.
No. So in relation to Dr. Charwa's evidence, of course, it's set out 65 onwards. And my lord, you just referred me to paragraph 120 and then
71.
71.
Those are the two where Miss Grief said there was or submitted.
Is Mr. Bicker
Mr. Bicker.
It's particularly an exchange with Mr. Bicker, I think.
Apologise.
Yes, so in relation to paragraph 71, in essence leading into to 72, but the point is this, that the baby's cry would have changed. Dr. Choll was very clear about that. The time and the way in which it would have changed, we know can be variable, and that's what Dr. Choll was said. And certainly in both my submissions and those of the local authority, the specificity that she puts in relation to that, she sets out as being something of a guesstimate or an estimate in relation to how the baby would have presented and how long before the injury would have been noticed that the baby would have presented in that way. But in relation to paragraph 71, and the fact that the pain cry wouldn't have been heard if it had been caused on the 3rd of December, the point is this, that Dr. Charwer said that whilst there would have been a momentary change of cry, that period of distress, and that's the immediate distress post-fracture, would have lasted between 30 minutes to 2 hours. Mm-hmm. And so there's a distinction between that immediate scream and pain, but then that heightened level of distress, which is different from the baby being unsettled. And that's the point, I think, that Dr. Charwer makes, and that's the point that she was clear about in evidence. Does that assist you, Lordship?
I think the point that you need to grapple with is that in 71 and also in fact 75, what's recorded is that Dr. Chawla said that somebody who was not right there may not have noticed any change in the cry of the baby when the fracture was caused. So in other words, she's just there talking about presumably conscious people, but just saying, unless you were right there, i.e. breaking the leg, it's perfectly possible that the change in cry, both when the fracture occurred and in the immediate aftermath, presumably, may not have been noticed by another person. And yet, in 120, the judge reaches a firm conclusion that even if the mother was asleep, she would have been woken up by that occurrence. And I think Mr. Bicker says, well, how do those two things sit together? That very firm conclusion in 120, which does seem to set the tone for a sequence of analysis, seems to be contrary to Dr. Chawla's evidence. That's the point which I think Mr. Bicker was short and to the point on.
He was, but we also have to think about what the aftermath would have been. We know the aftermath would have been that there was some change in presentation in relation to the leg. So whilst we have the cry and the fact that it's submitted that the mother couldn't have been expected to have woken up, that's only on the basis that she was soundly asleep, and that is her evidence.
In fact, you covered it even more broadly. I mean, Dr. Chawla was talking 71 and 75 about somebody not being right there physically, yes, in the presence of the breaking of the leg and the child. And then, rightly or wrongly, the judge concludes that they were both in the same room. They were in the same bedroom, so they were right there, if you like. But then the mother might have been asleep, and then she says that the mother would have woken up. So you could put it in that way to say there's no inconsistency, because here the judge was accepting that the mother was right there. She was next to the father in the bedroom, and she would have woken up because she was attuned to the baby and so on.
Yes, and
That's what you would put.
I accept that point. I
think, in fairness, Miss Rosie, I think paragraph 120, what the judge is saying is the combination of the immediate cry of pain and then the 30 minutes to 2 hours of ensuing crying and distress that would have woken her up. She's not saying that the immediate change of cries, the combination of things.
No, and I think that's the point. That this would have been a prolonged period during the course of that night, and this is a mother that the judge was fully aware of. This was a mother that had been expressing every 3 hours. She was a mother that, whilst she said that she slept all night, of course. You have to put this into the context of the facts in this particular case.
If they were in the same bedroom, she would have woken up.
At some point.
So it does come...
It also, we're about to stay in stereo, I suspect. It comes back to that sentence that was the couple's usual practice.
Yeah, I think so.
Which has been
mentioned sometime
Lord
ago.
Justice did point all day.
and it's a circular argument because, of course, neither parent remembered that anything unusual happened that
So
night.
as I put to Mr. Bicker, that phrase carries a lot of weight in this judgment, Miss Worsley.
And that's the difficulty, and that's why I submit, well, nothing unusual happened, because it wasn't a memorable night. And the father says the baby was unsettled. The baby was always unsettled, or often unsettled. And so I say that the baby that night, there was nothing unusual about it, which is why the mother remained asleep, because if the father had been in the bedroom with her and the baby had been crying, as we know from Dr. Chulwer, then the judge is right, she would have woken up.
But the point being, it all hinges on the judge's finding that they were in the same room, because if they weren't, it falls apart, doesn't it?
It doesn't, because even if the father was downstairs with the baby would have been in heightened distress for certainly 30 minutes. We know that, after the sharp pain.
Yeah.
And so the likelihood of the mother not reacting or not being disturbed, I said the judge was entitled to conclude that was unlikely.
It's not what the judge concluded. The judge doesn't deal with that point.
No.
She doesn't say in terms, even if I'm wrong, the child father was downstairs with the child, I'm satisfied the mother would have still woken up. She doesn't say that.
No, I accept she doesn't say that, but that has to be the logical flow from that. And what my main point is that the fact that nothing of consequence was reported on that night is because nothing happened.
Yeah. But if the child was downstairs, you've got the additional problem that you've then got the discrepancy with the Dr. Chowder's evidence and the paragraph, because they were not then in the same place.
Not right there.
And the mother was sleeping. There'd be two barriers to sensitising the needs of the child, if you follow me. So
Yes.
I think it is critical that the judge finds they are in the same room, and then the judge finds she's bound to have woken up because she was in the same room and the baby would have cried for half an hour to an hour.
But also,
Would have slept through it.
I accept all of that, but also the point is there would have been a change in the presentation of the child's leg, which this mother, on this judge's analysis, would have realised on waking in the morning.
Or on
So there's a
the
constellation of
4th, or
factors.
on the morning of the 5th. And she never said anything about that. And you say she didn't say anything because she was covering it up. Covering up what she'd done.
Yes, that's the father's case.
It's your case, yes.
Yes.
Can I move to something slightly different?
Yes.
Miss Rosie says yes with relief. I hope it's not unhelpful to have this exchange, Miss Rosie.
No, of course not.
Well, you say no, of course not, because sometimes,
Could you be polite?
you may be polite, but sometimes we're told we interrupt too much. But I, for my part, sitting in the family cases, I don't find that's a problem. I hope you don't. Just going back to something else, a bit different. What do you say to Miss Grief's argument that the judge's approach to the rib injury findings was wrong? What she should have done, instead of saying, focusing exclusively, we've all focused on the third of the leg because it's more sort of the evidence is more in focus, as it were. But Miss Grief says, well, before she made a finding about the perpetrator of the leg injury, she ought to have looked, under ET, totality of the evidence, ought to have looked at what happened with the with the rib injuries. Instead of which she said, I make a finding focusing exclusively on the leg injury, and therefore there won't be two perpetrators here. Therefore, the mother caused the rib injuries. Now, what do you say about that? Is that do you accept Miss Grief's characterisation of it, and if so, why was it not wrong?
I accept the characterisation that that is what the judge did. This is obviously in relation to ground 5 of Miss Grief's submissions. And I know that some questions have been raised in relation to that in any event about paragraph 51 of my submissions.
Yeah.
That's at S253.
It's a process point, really, rather than looking at the details. I mean, if you've got a child with... In a case like this where the perpetrator is the key issue in the case, there's evidence going both ways. We're all agreed about that. The judge came to a certain view, and you say that's the judge's entitled to. But what Miss Grief says is, before she came to a decision on the perpetrator of any of the injuries, she needs to look at them all together. Need to consider them all together. Each, whatever that phrase is that I quote all the time in the judgments of Lady Justice Butler-Sloss. Each piece of evidence has to be considered in the context of all the other evidence. Well, that's roughly what she says, isn't it? So why do you accept that? And do you say the judge did that here? And if she didn't, was she wrong?
I do accept that she has to look at each piece of evidence, of course, separately. In relation to the rib fractures, of course, on behalf of the father, we focus very much on the times when the mother wasn't present, because at all other times the mother was in the house. And of course, the point is that Miss Grief makes the point in relation to the escalation and changes of crisis on the 24th. Much was made of November. Much was made in relation to the 45-minute period when the father was alone on the 25th, and the fact that in fact the baby was crying, but there was no other concern raised by the mother on her return home. That was the longest she'd ever left the baby, in fact, with the father. But so far as looking at each set of injuries, no, of course the judge needs to do that.
But you see, what she does in the paragraph 134, she just says, having found the mother caused the leg injuries and that there is only one perpetrator in the case, it follows that I find the mother caused the rib fractures. Miss Grief says, before she came to have given the arguments both ways on the leg fracture perpetrator, she ought to have considered the rib fractures more fully in terms of perpetrator before making her finding on the perpetrator of all of the injuries.
But my lord, she does, because there are two sets of rib fractures, and she refers to the earliest set, and that's at 135. And so we have to look at the context of that as well when considering the evidence as a whole. So I think rather than focusing on the 25th of November, I think it's important to look at the earlier rib fractures. So in relation to paragraph 135, that's at page 23.
Yeah.
She sets out about the night of the 14th to the 15th of November. And you'll know in my skeleton argument, I set out, and in fact they're in the bundle.
Just remind me of the windows for the rib fractures, would you?
Well, it's the 9th to the 23rd for the first, and then the 23rd onward for the second.
Thank you very much. All right, that's 23rd. Okay. All right, so that's quite a big window, as you expect with rib fractures.
But the judge was entitled, as she did there, to conclude that that was the time when those initial rib fractures had been caused.
Well, that's yes, but she does that on the back of, or following on from, her finding in the first sentence of paragraph 134. Doesn't she?
Well, I think she does, but she also is looking at it in the round, because she's referring, whilst she may not have explicitly said that, it's clear that she has considered each set of injuries separately, because it's clear at 135 that she's considering the most likely period of time when the rib fractures had been caused.
Yes, but forgive me, but isn't she doing that having already found that the mother caused them?
Yes, at the beginning of 134, that she sets that out.
Yes, so I mean, the point being, if you condition your mind by making a finding, as you do at the start of 134, based upon the leg injuries, the argument against this judgment in relation to this point, I think, is exemplified by the middle of 135, where the judge is sort of saying in the second and third sentences, really, it's clear there was a terrible night on the 14th to 15th assault which could cause the most loving mother to lose control. In other words, she's sort of assuming to what she's sort of assuming that that's supportive evidence rather than actually analysing whether it independently it tended to prove anything at all. And then the fact that B was relatively settled on the 15th and 16th doesn't mean that the fractures were not present. But in a sense, she's just explaining the conclusion she's already reached. I mean, taken independently, if you started from the other end and just said, well, if there was a terrible night on the 14th to 15th, and then a baby being settled on the 15th and 16th, sorry, terrible night on the 14th to 15th, so the night of the 14th stroke 15, but then the baby was settled on the 15th, 16, what does that tell you? You wouldn't immediately come to the conclusion that the mother had caused the rib fractures on the first of those nights, would you?
No, but she goes through in some detail at paragraph 80 onwards in relation to the opportunity, and she sets out her conclusions in relation to how she interprets the evidence that she's heard, and she does that before she then makes the conclusions in relation to the leg fracture. So I would submit that she is looking at the evidence as a whole when she does that, when she comes to the conclusion in relation to the findings about the weekend of the 3rd to the 5th of December.
Mm. Well, the father had the opportunity, she finds, at 196, doesn't it? Doesn't she? Both sets of rib fractures.
She does, but of course she reminds herself that opportunity doesn't
No, it doesn't.
perpetrator.
But the argument is, Miss Grief's argument is, that she should have looked at all the evidence about the rib fractures, I'm repeating myself, as part of her analysis of all the fractures, not looked compartmentalised. The leg fracture, without bringing into account the evidence both ways about the rib fractures.
Yes, and I accept she doesn't specifically set out some of that rationale. I accept that.
This is, those of you who sit there, it's a very difficult exercise to do. Very, very difficult. We haven't made life easier in how we've required judgments to be structured, I know, but there is some force in Miss Grief's point, it seems to me, that the rib fractures are taken sequentially rather than as part of the overall analysis. Gosh, it is difficult to do that. And okay. So
the impression that I get is that the judge thought, if I can be sure who did the leg fracture, then that person must have done the others, because only one perpetrator. Nobody's suggesting they did different things. It's only one perpetrator. And 64 says the rib fractures was the 9th to the 23rd of November. So you've got 14 days for the first rib fracture. And 134 to 136 seems, on one reading, to say this. I know she's done the leg injury, see above. She could have done the rib injury too. She could have done it on the 14th to 15th. Therefore, my thesis that it's her and only her isn't upset by the rib fracture issue, because I know 2 days when she could have done it. But that isn't the question. The question is, who and when was it done in the 14 days between the 19th and 23rd of February? That's the difficulty with those passages. And to go back to the theme that I know my Lord Justice is getting tired of, it might have been helpful to deciding whether or not there was a break in the common practice that night, or it might have caused you pause for thought. But you've had we've gone through that. You know what the argument is against you. We've just got to decide whether it's right or wrong.
There are many cases, and you probably find a judgment of mine, which I've done, in which we can finding you have to start somewhere. You can't keep going round in circles. Eventually you have to jump in and make a finding. And there are judgments where, lots of judgments where you say, and having found that on the leg fracture equivalent, I therefore conclude that the same perpetrator was responsible for other injuries. You don't always do that, of course. But there we are. Difficult case, Miss Burgess. Right.
Can I assist you with anything?
I rather sort of hijacked your submissions by asking you about that particular point.
No.
I'm sure I gave Mr. Fearn a chance. I might ask Mr. Fearn.
I'd like to, if I may.
Yeah, I think with fairness, Mr. Fearn, I want him to have a go at that point in a minute. Is there anything else you want to say? Anything else?
I'll just turn my back for a moment. No, I was thinking.
Right.
Well, just really quite briefly in relation to that point, which is that the point Miss Worsley makes might perhaps engage your lordships in a little more detail, which is that although there is that paragraph in which it says, having found the leg, therefore I find this, she then goes on in the following two paragraphs to say, in addition, I find this for these reasons. Mother on the 14th.
Should we have a look at that a bit more?
Yes. That's not
1, 3,
exactly what I'm going to take your lordship, but let's start there.
Okay. 1, 3, 4. Yeah.
The 134 is where she says, having found the cause of leg injuries, only one perpetrator follows, I find mother cause of rib fractures. Cannot say with certainty when the radiological windows where this happened. I have lots to do and so on. I agree with the authority submissions, the likely dates.
The whole, I know what you're going to say about 134 to 136, but it all follows on from what she's found in the first sentence of 134.
My lord, it does, but I do preanate some other things which.
Yeah, I mean, you want to go back to earlier.
Back to the opportunity
okay,
section.
right? Okay.
And then back to, I think it's around paragraph 80 onwards.
Yeah. So, thank you. Yeah.
In particular, I won't go through them. I won't read them out. Your lordships take note of them. Perhaps particularly from 86 onwards, the judge has gone through the fact that for the first 2 weeks of this child's life, the father was the main carer.
Yeah.
And at 86, she said, father continues the main carer for B until he went away with work on the 14th. A short video of him winding the child on the 13th was produced, but there was nothing to show the child was actually injured at that stage. There was very heavy-handed winding. There was no evidence of anything of concern in the period from the 9th, which is the beginning of the window, the radiological window, to when the father leaves for work. The health visitor told the child on the 12th and did a top-to-toe examination. Then the father comes home on the 17th, and she goes through various matters within the paragraphs. By the 17th, the child was unsettled. The father looking after the child overnight brought B down because the mother wanted to sleep and was getting annoyed and so on. So she goes through chronologies during the course of that time. And as I say, I don't want to take your lordship through it line by line in submissions, but the judge does narrow down when whatever the radiological window was, what the time windows of concern to her were in that section. So that when she comes to a judgment, which I accept, she says, it follows from X that I find Y, she has conducted at least some analysis of the narrowing down the time windows prior to doing so.
You're right, and it's not just about opportunity, there are other grounds too.
Exactly.
Your case, local authority's case at the outset was pool finding on all injuries. Was your case at the end mother on all injuries or pool finding rib fractures? Or
mother on all injuries.
Mother on injuries.
Having seen
because
both cross-examined.
Because what we've said, what she says at paragraph 91 is that the local authority submits that it's possible the father caused the fractures in this period, saying the 25th. So obviously you've been running that case during the hearing and cross-examining on that basis. But Miss Greaves' point is, shouldn't all this have, yes, she sets it out here, but shouldn't she have analysed all of that again before making her perpetrator finding?
My lord, yes, and if one were policing a counsel of perfection, one would say, I'd rather you put that later in the judgment and dealt with it in that way. And then the question is whether it meets the Barclay standard.
Well,
right.
The fact that if it's there, the fact that it's in one place, the judgment of another doesn't matter. The question is, it's sufficiently dealt with.
Yes. That's all I wanted to add.
Thank you, Mr. Fearn. You'd finished, hadn't you? Yes. Yes. That's great.
My lords, I made 3 notes and crossed them out as the rest of the comments took place, because they were covered by further questions. So I don't want to take up any unnecessary.
Where are we? So where are we with the? So B is still with Granny,
Yes.
having contact with parents.
Yes.
And when is the case next listed?
September.
August the 2nd.
Oh, August the 2nd. Thank you.
August. That's right.
I hadn't been made aware of.
For what? IRH.
Case management here, I understand.
Okay. Is there a local authority? Is there a care plan yet? On the if the findings are sustained.
I think the care plan was
Return to
remain
father.
with grandmother.
Remain with grandmother.
No, there's further
return to
assessment being undertaken. at the
Further
moment,
assessments. Okay.
I'm sorry. Yeah.
in relation to the mother, but of course it hasn't started, and it won't start until the conclusion of this appeal.
Can't start after.
Of course, until the decisions have been made.
Okay.
So that is lined up, I understand, to commence once the position's settled.
The collective view of this court was this tried at quite a long time, stretched over 6 weeks. Was it 15?
No, 3 weeks.
3 weeks. How many days altogether?
I'd have to check.
50. It was.
I think it was over the Easter break.
No, it
as well.
stretched over. I see. It was 15 days. I mean, that is quite a long time.
Yes.
So that would be a rehearing if we allowed the appeal.
Sorry, so how many court days in total?
I'd have to double check. I thought it was 3 weeks.
I think it is
in fact.
15.
I think it was stretched over 4, but that was
Stretched over longer.
holidays.
All right.
I think it was 3 weeks in time.
In court time? In court? I 15 days in court?
No, I'm sorry. I
Sorry,
hadn't recalled. In fact, it's some time ago now. But I know that there was certainly a break over Easter, maybe for 5 or 6 days.
Yeah, it's probably on the order, isn't it?
Yes, it will be. I can have a look.
But anyway, so I think 3 weeks is quite a long time. As I say so. You don't agree?
Indeed, my lord, the issues as to testing the other medical evidence is now completely
All gone.
and was
So
accepted to be
if we
the
had a
case.
rehearing will be shorter.
Absolutely.
Okay, all right.
It does say 15
Yes.
days.
And also, if I may rise as well, there were some issues during the trial in relation to further evidence coming to light. And so there were, certainly I think on 2 days,
Okay, stuff
there were delays for the statements to be taken.
Okay,
So
all
I
right.
think as far as the oral evidence was concerned, it
Okay.
was certainly truncated in relation to the number of days.
But if we allow the appeal, as you can say, it's very anxious scrutiny we should give to this. But we have to go to another judge, back to probably Miss Justice Poole to nominate.
Marvellous.
Okay. Right. So well, we will try and get this sorted before the end of term, but I'm not sure whether that's going to be possible. We'll do our best. If not, it will be September. We're going to reserve judgment, obviously. We're going to send out our judgment at some point on the usual basis for counsel to point out any errors or typographical errors or factual errors, not to re-argue the points. Please bear in mind what's at the top of the judgment, that it's confidential and it's contempt of court if that's broken. When we do that and send you out our drafts, we'd be grateful if you would, in agreeing to, in addition to it, sending any corrections, try to agree an order consequential upon our findings and our judgment. If you can't agree, please put short submissions in and we'll resolve those issues in writing. Very grateful to all of you. Thank you very much.
Thank you.